Let the participants in. Think we got everybody. All right. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of evictions and knowing your rights. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. But also included is the City of Houston's Department of Neighborhoods and our presenting partner representing Lone Star Legal Aid. Today, we have Mr. Benjamin Daly, who will be providing the information for you all about evictions and your rights. But also included in the partnership, we have the Earl Carl Institute, Texas Legal Services Center, Houston Volunteer Lawyers, Harris Central Appraisal District, Harris County Tax Assessor Collector's Office, and Houston Bar Association. And together we make up A Month of Service. And basically, A Month of Service is the collaboration of all of our organizations. We come together each month and have been coming together for the past several years in an effort to reach more people, to create a larger impact, and to get as much information out to the community as we possibly can relative to community empowerment, asset building, asset protection, and the maintaining of generational wealth. We know that there are a lot of underserved communities that are out there that have limited access or don't know where to go for particular information or for resources. So again, we wanted to try to create a larger impact by coming together and collaborating all of our different initiatives and trying to, again, get as much information out there as we possibly can. By switching to the virtual platform, it has allowed us the opportunity to reach people outside of the city of Houston and Harris County, but as well as the surrounding counties and even across the state of Texas and across the country in some instances where people join us live on our social media platforms. This is your opportunity to ask questions that you may have regarding today's topic, which is evictions. If you have particular questions in regards to your own similar situation, we ask that you contact our legal service organization partners like Lone Star Legal Aid outside of this presentation, due to the fact that we want to keep in mind that we are recording the session as well as broadcasting live on our social media platform on YouTube, and we'll be providing the link on Facebook as well. So we don't want your personal detailed information kind of getting out there for everybody to have access to. So do keep that in mind when you're asking questions. Just try to be as general as you possibly can with those questions. In addition to that, should let you know that the information that does get presented here today, as well as any of our other legal presentations, is for educational purposes only. It is not to be considered legal advice. However, again, we do encourage you to reach out to legal service organizations for any kind of assistance that you may need regarding your civil cases. And Benjamin's going to go into a little bit more detail about the other services in addition to eviction prevention with Lone Star as well, so that you are aware of what other services are available to you guys. So with that being said, thank you all very much for joining us this afternoon. For our returning participants, thank you for continuing to support the A Month of Service collaboration. For those that are new that may be joining us, we want to welcome you and thank you for tuning in today. Following the presentation, you will see a link that pops up on the screen. We ask that you just take a couple of minutes to complete the survey so that we can kind of receive your feedback and let us know how we're doing. Did you get the information that you intended to receive when you joined in today? If there are any particular topics that you all may be interested in, as we are planning our 2025 schedule. So we want to try to keep in mind what it is that you all, what kind of topics, what kind of issues are you all facing, and what's kind of relative to you and to your community. If you could just reach out to us and let us know. And if these sessions have been beneficial to you, we also want to hear your story. We want to hear from you too, and see, and just kind of let us know, hey, yeah, you guys are doing a great job, and this is how it's been helpful to me, and so on and so forth. So we'd love to hear that from you guys. So With that being said, we are going to go ahead and let Mr. Benjamin Daly introduce himself and provide you all with the information. I'll go over a couple of other upcoming workshops at the end that we've got coming up so that you guys can hear about that. But in the meantime, Mr. Benjamin Daly with Lone Star Legal Aid, we can go ahead and proceed.
Okay. Thank you so much. So my name is Benjamin Daly. I'm a staff attorney with Lone Star Legal Aid. I specifically work on our eviction right to counsel unit. And this is Eviction Know Your Rights. Before I get started, special thanks to Kim DK, who helped create this presentation. One moment. So Lone Star Legal Aid is a 501c3 nonprofit law firm. We specialize in representing low-income individuals in a wide variety of civil legal matters. We have both specialized units like the eviction right to counsel unit, as well as some general units that are tailored to assist specific populations, such as our veterans unit. We can offer services as far as simple advice to full representation. If you need to apply, we have our website down here, and we'll have some more information at the end. Brief note that for today's session, as was said, I can provide some general answers to questions, but I can't give anything more specific. If you're looking for assistance, I highly recommend that you apply with us. So today's agenda, first thing we're going to go through information about the leases and how those are terminated. Then we're going to get more into the procedure of the forcible detainer suit, which is the legal name for an eviction. We're talking about notice to vacate. We're going to talk about the suit themselves. We're going to talk about what to expect in justice court and if you need to appeal going up to county court. We'll talk about some special cases such as public and subsidized housing. We'll talk about some rights you might have outside the eviction process, such as if you're locked out or if the utilities are shut off. And finally, we'll talk about security deposits. Again, this is general information. A lot of these cases, the outcome is determined by specific information, so just keep that in mind. When in doubt, make sure that you're asking for legal help. And then we are going to be talking a little bit about some affirmative cases that someone could bring against a landlord. Our recommendation on those is to talk to an attorney before filing any lawsuits. And again, general questions only, but I'll be happy to answer those at the end of the presentation. So first things first, leases. A lease agreement is the contract between a landlord and tenant establishing a landlord-tenant relationship. Texas allows for both verbal and oral leases. Keep in mind that if you do have an oral lease, you're going to want to make sure that you're documenting what the terms of those lease are. The terms of the lease are going to control in virtually all disputes between the landlord and the tenant, so they are very important. When you have a lease that's for a certain amount of time, we call that a lease of years. When it's a shorter time and renewing, such as, a month-to-month lease, that's obviously month-to-month. The difference between those two is very important, and we'll talk about lease terms in a bit. Keep in mind that if you have a lease term longer than a year, that agreement must be in writing. If you have a written lease, you have the right to a copy of the lease within 3 days of it being signed by all parties. If you do not receive a copy of the lease, make sure you ask for it in writing. Apologies. Like I said, the lease terms themselves are very important. Don't just sign a lease, you want to review it. A lease is going to tell you what the monthly rent is, where and how to make payments, if there are any late fees, and how payments are to be applied. It'll contain information about the initial lease term. So, most leases that we see are for a single year, but there may be some that go for longer and some that go for less. Keep in mind, too, the lease may contain language that the end of a lease term automatically renews a lease on either a regular or month-to-month basis. So you want to know what happens at the end of the lease term. It may contain information about committee rules and policies. It may contain signed addendums. So if you have a housing voucher, that's the HAP contract. If there are any concessions, those are going to be part of the addendums. You do also see addendums dealing with things like utilities, dealing with things like pets. I've seen lead addendums. I've seen bed bug addendums. In most cases, the signed addendums are incorporated into the lease through language in the lease itself. So treat any addendums like they are part of the lease. Acts of default. Every lease is going to say what constitutes a default. So, for instance, failure to pay rent, material breaches. So, for instance, if you violate committee rules and that's a material breach of the lease should contain some language referring to the community policies. It might also establish special rules about early termination or holdover. And finally, and importantly, the lease should give some information about timelines. Now, timelines can be established either under the lease, or if the lease does not establish them, then they are established under the statutes. But keep in mind that the lease itself controls. And in a lot of cases, these timelines can be changed from the statutory timelines through the lease. So terminating the lease. After an initial lease term, both landlord and tenants have the right to terminate the lease with the proper notices per the timelines agreed to in the lease. This is accomplished through a notice of lease termination and notice of non-renewal. The lease will contain the language regarding what the timeline is. The statute by default requires a 30-day notice to terminate the month-to-month lease. But again, that can be changed to, we see some that require 60 days. We see some that require less time. So absent any language in the lease, the statute controls. If there's language in the lease, the lease controls. The termination of the lease has to be in writing. So just keep that in mind. It's not something that you can accomplish through verbal warning. You actually have to get a physical written notice. Except in very special circumstances, you can't make your landlord renew your lease, just like the landlord cannot make you renew your lease. Now, if the lease is terminated during the lease term, not the end, but in the middle of the lease term, we call that an early termination of the lease. Terminating the lease during the initial lease term without consent may subject you to certain fees or penalties. So, for instance, if you're looking to break your lease, keep in mind the lease may require that you pay a penalty for that. Now, the statutes and the property code do allow tenants to exercise rights to early termination in some specific circumstances. And so we're going to talk about those now. Keep in mind that these rights to early termination are established under statute. The statutes are going to be very specific about what is required as far as notices. So our recommendation is that if you're going to terminate early through one of these, that you review the statute. If not, talk to an attorney about it first. So in certain cases, family violence and certain sex offenses and stalking, these can be grounds to terminate the lease early. Those grounds cannot be waived by the lease. If a tenant dies, that is grounds for an early termination. That allows you to avoid future liability, but past due obligations may still accrue. So, for instance, if there's unpaid rent, if there's damage to the property, the estate may be responsible for that. Notices in the lease are not required in that circumstance. And then certain decisions related to military service, that can give somebody the right to an early termination, although that is one ground where that may be waived by the lease. Oh, also worth noting, some of these statutes, if the landlord violates them by refusing to allow a tenant to terminate, or if they attempt to charge certain liabilities to the tenant, there could be a cause of action against those landlords. So again, if that's a situation you're dealing with, we recommend that you speak to a lawyer about that. Another important ground to know is casualty loss. So casualty loss is when you have basically a natural disaster or some form of disaster that renders the property, at least in part, unusable. If the premise is made totally unusable for residential purposes due to casualty loss, and the loss is not the result of a tenant's fault or negligence, tenants have the right to terminate the lease with notice. Keep in mind that that same provision also allows landlords the right to terminate the lease once the property becomes totally unusable. If the premises are basically involved in a casualty loss situation, but they are only made partially unusable for residential purposes, and it's not the result of a tenant's fault or negligence, you do not have the right to terminate. However, you can petition the courts for a reduction in rent. At the same time, 92.054C, which says that if it's partially unusable, you can't terminate, that also goes for the landlord. The landlord cannot terminate the lease because the property is in part unusable. Keep in mind that whether a premise is totally or partially unusable, that is a question of fact. That's not something that is something that would have to be litigated if there's a dispute about that. Keep in mind, too, that some of this can be waived or altered by the lease. So, as always, review the statutes. If you need, please speak with an attorney. Now we get on to sort of the meat and potatoes of the eviction itself. Most evictions that we see that happen in the middle of a lease term, those are going to be because there is some breach of the lease. The breach of the lease is defined by the lease agreement. That can be something like a conduct-based eviction where somebody breaks a rule. That can be non-payment of rent. Those are going to be established here in the lease or the addendums. If there's a question about whether something's a breach of the lease, that's where you want to look to. So again, some common defaults: failure to pay rent, repeated violations of community policies, unauthorized tenants, criminal activity, or holding over. Holding over is when you stay beyond your lease term after there's been a termination. This is sort of the threshold issue of any eviction. If there's no breach of the lease, there generally is no right to get an eviction. If a breach of the lease occurs, the landlord then has to take steps before they file an eviction. And we're going to talk about that next. Oh, I'm sorry, we're not talking about that next. Some specific facts patterns that we sometimes see. Withholding rent is something that unfortunately we see too often, where somebody, usually the fact pattern we see is somebody asks the landlord for repairs, the landlord doesn't make repairs, and so the tenant doesn't pay the rent. That is never a good idea. Texas law always requires that rent be paid in full and on time as it comes due. If you withhold the rent, that could subject you to an eviction for non-payment of rent, regardless of whether or not you had a good reason. Additionally, it's bad legal strategy if you're looking to get repairs or retention. You must be current on rent in order to maintain your rights. Once you fall behind, your landlord does not have a requirement to fix anything in your apartment. If you're having issues obtaining repairs under the lease, or you have issues that threaten the health and safety of the tenant, it's important that you send your landlord a request in writing. We recommend via certified mail. It's important that you contact a legal professional. You do have rights, but you shouldn't withhold rent in those situations. Sorry, I can't find my... second case that we sometimes see I've seen this actually fairly recently, so I want to spend a little time on it. What happens if you as a tenant are tendering rent in full and on time and the rent is refused? Landlords generally are not free to refuse properly tendered rent pursuant to the lease agreement. Now, the landlord can refuse rent if it is late, if it's a partial payment, or if the lease has been terminated. Landlords also have the right to determine what manner and which amounts the rent has been paid. So, for instance, if your lease requires that you make payments via money order sent to the leasing office, and you try to pay them via Zelle or direct deposit or with a credit card, they can refuse those. That's not properly tendered rent. Tenants who have had this issue need to do a few different things. The first thing is you need to review your lease and current ledger to ensure that the amount covers the rent and any other fees or payments that are due in a manner consistent with the lease. So all rent, all utilities, if there are late fees, make sure you're paying those. Sorry. Um, you want to make sure that you actually are offering the correct amounts. Second, most important, make sure you're documenting all of this. I had a case recently where I had a client who had tendered rent timely, but had not documented that she had done that, and that affected her ability to raise a defense in trial. So make sure you're documenting the date and the manner of payment. If you have the ability to make a payment in a form that can be traced, so for instance, a money order, make sure you're taking pictures of the money order. If you're doing this via direct deposit, make sure that you're documenting that that's been paid. Make sure the date is documented so that you can show it wasn't late. Once you've made that payment, document correspondence with the landlord. If you have to go and turn in the payment in person and they're refusing it, take out your phone, make sure that there's a video of you trying to pay the landlord. If you're sending this via portal and it's getting bounced back, make sure you email the landlord and make sure that they know that you're having this issue. And then save any responses too. If they tell you that we're not interested in taking your payments because of X, Y reasons, make sure you save that email so that you can show a judge. Equally important, rent is always owed in full and on time as it comes due. Obviously, if the landlord is refusing the rent, then you've kept your end of the bargain, but the rent would still be owed. So make sure you're keeping the payment or funds for future payment, if applicable. If this is an ongoing situation, make sure you're sort of repeating these steps for every month. So if your landlord refuses rent 1 month, don't assume that they're not going to take it next month. Make sure that you're offering the payment again in full and on time and documenting that you've made the payment. And finally, most importantly, contact an attorney for assistance on one of these. It's always best that somebody look at this early in the process rather than scrambling at the end to try and defend you on this. So we've seen this far too often recently. It's important that if you're facing this, that you take these steps, document it, and give us a fighting chance if this sort of does come into litigation. One other thing, sometimes we see this if there's a dispute over the amount owed. So if there's a high utility payment, sometimes people say they don't want to pay that. The landlord might refuse that. If there's a dispute about the amounts, I would recommend making the payment, contacting an attorney, and potentially suing over it later, rather than risking eviction by not tendering the full amounts. So just something to keep in mind. Now we talk about notice to vacate. This is the first notice that you're likely to receive in any eviction proceeding. It does need to be given to the tenant prior to the filing of any eviction. This is a requirement under the property code, and the notice itself cannot be waived. Notice has to be for the right amount of time. It has to be delivered in a particular way. In most cases, the notices are going to be 3-day notices, unless the lease requires a shorter period or allows for a longer period. The notice to vacate can be delivered in, I call it 3.5 ways, because there are 3 ways in which you can normally do it, and one that's sort of an exception. The normal ways of doing this, they can either hand deliver this to you, they can send it to you either by regular or certified mail, or they can post the notice on the inside of your front door. As an alternative, in certain instances where those 3 forms of delivery aren't available, the landlord can post the notice outside the door. It has to be an envelope. It has to be affixed firmly to the outside the door. So they can't just slip it in the crack of the door. They actually have to have it affixed to the outside the door. The landlord also has to mail a copy to the tenant by placing the mail by 5 on the same day. And the landlord has to prove that certain circumstances have happened. So they have to show why it is they had to use the alternative rather than the 3 other versions of the notice delivery available to them. It's important to note that an eviction suit fails if notice is improper. Always document how you're receiving these notices if you're getting them. If they're being shoved in the crack of the door, that's not proper. You want to document that it's been posted that way. If it's put on the outside of the door, you want to take pictures of that before you take it down. Make sure it's documented that way. Documentation of the notice could be the difference between you winning your case and you losing your case. So it's very important. Another thing to note for a special case, the CARES Act. CARES Act is COVID era policy. It was passed at the beginning of the COVID pandemic. And basically Congress passed it in order to provide some relief to different groups, including tenants. Originally, the CARES Act provided a 120-day moratorium on evictions. At the end of that moratorium, though, they created a new requirement that landlords provide 30-day notices to vacate to certain sorts of properties. So covered property is any property that is in a covered housing program, such as under VAWA, or if they're getting some form of federal funding, such as if they're receiving Section 8 housing choice vouchers, or if they're receiving low-income housing tax credits. They can be covered if they've got a federally backed mortgage. And those can include single-family homes, duplexes, mobile homes. So basically, if they're receiving federal money and their program is listed under the CARES Act, there's a requirement they provide a 30-day notice to vacate. It's important to note that if you think you have a CARES Act defense, you really should talk to a lawyer, not because it's not a valid defense, but because we've seen these sort of hotly litigated. Our position is that the CARES Act very clearly is in effect, but we've seen some judges be resistant to that, and we've seen some attorneys argue it's not. So, those are good cases for us, and they may cause a pro se litigant issues. So we recommend seeking legal assistance if you have one of these. Keep in mind, in order to find whether you have a CARES Act, there are some databases available, but not all of them have been updated. The way we normally find these is we look at the property records, or we ask the housing authority whether or not they're covered properties. That's not a reason to come to attorney if you think you may have a CARES Act defense. It's just we'd be able to either confirm or dissuade you concerning whether or not they're covered by the CARES Act. Now we get to the actual lawsuit itself. So the fancy name for an eviction is a forcible detainer suit. The main issue in any forcible detainer suit is the right to possess the property. The landlord can attach a suit for rent, but they can only ask for back rent in those circumstances, plus court costs and attorney's fees. They cannot ask for utilities. They cannot ask for, any late fees. And they can only ask for money if this is they can only ask for damages if this is a non-payment case. They can still ask for attorney's fees in a conduct-based eviction or holdover case. The main thing that a landlord must prove, they have to prove ownership of the property. They have to show a breach of the lease or termination of the lease. They have to show proper notice under property code. And they have to show that you as a defendant refused to leave prior to the deadline provided under the notice to vacate. Again, notice not payment of rent cases. They can add a suit for rent, but they can only ask for the back rent amounts. Attorney's fees and court costs are always available. Well, let me rephrase that. Court costs are always available. Attorney's fees, if they're provided under the lease or if there's certain sorts of notices saying you may incur attorney's fees, those are available in cases where there aren't other damages, but rent is only recoverable in non-payment of rent cases. We often get asked about jury trials. Most evictions are done by a bench trial, but you do have a right to a jury trial. Jury demand must be filed and the fees either paid or waived 3 days prior to the date of trial. If there's a situation where you timely file for jury trial, you pay the fees, and you're told that you're not going to get a jury trial, please call us or speak to an attorney. So as a practical matter, all forcible detainers are likely to start in justice court. Justice courts use simplified procedural rules. They don't have to follow the rules of evidence. And so those rules can differ greatly from court to court. The reasoning behind that is that the justice court, at least in theory, is supposed to be a sort of court where any person can go and have their case heard without the need to have specialized knowledge in litigation. So it's designed basically so you don't need an attorney. If you do find yourself in eviction, this is going to be sort of the first big hurdle. Make sure that you arrive to court on time and have everything you might need for a trial. My recommendation actually is to get early, just so you kind of have a chance to settle in, and also to make sure that if there are any issues that you have as much time as you need to get there. The check-in process can be important because if you don't properly check in, the court might not see you there and they might issue a default judgment against you. Some courts are going to call dockets while all others are going to have you check in with the clerk. If you have questions about how they are going to do check-in, find a clerk and ask. Some judges prior to trial, they're going to give instructions on how the court procedure works. Other courts just sort of jump into it. Once you get called up, judges generally begin by hearing the plaintiff's case first. Then they give the defendant opportunity to respond. If you're at trial, make sure that you're prepared to answer your judge's question and provide evidence of your defenses. Some judges require prior to trial that you talk with your landlord. That can be a good opportunity to settle your case or to discuss it with your landlord, what you want to do. Other courts provide community groups that provide assistance. So sometimes there are some courts that we cover where we will be present to provide legal assistance. So it's another thing that you can avail yourself of. If you need special accommodation, such as a Zoom hearing, make sure you call the clerk of the court and ask for help. And make sure you do that early in the process. Not all courts will give you a Zoom hearing on the day if they require you to be in person and vice versa. So it's important that you take steps prior to trial to make sure that any accommodations you need are met. We often get asked about whether or not it's possible to buy more time. Trial generally can only be reset by motion of the plaintiff or by the agreement of both parties. So if you're in trial and you're asking for more time, the judges are almost certainly not going to give it unless there are special circumstances. At the end of trial, the judge is going to issue a judgment in favor of one party or the other, or they may dismiss the case. If you can, get a copy of the judgment for review and for your files. If you're in this position, a lot of people are understandably frustrated. It's important that that not show in front of the judge. Always make sure that you're respectful to the judge, to the court staff, and even to opposing parties. It'll go a long way in making this process go easier. Like I said, some judges require that you discuss your case with the other side prior to going to trial. What they're looking for is basically some form of settlement. Settlement is basically an agreement between the parties to address the issues in the case without needing to go to trial. Judges require sometimes that you talk. Others have mediators available to help facilitate settlements. Others provide standard forms. Like I said, each court does this a little differently, simply because there aren't common rules between the courts. Make sure that you know that settlement agreement requires both parties to agree to specific terms. You get to determine what those terms are, but both parties have to agree at the end of the day in order to have a valid settlement. Like I said, courts provide these standard forms in some cases. Make sure that you're reviewing those agreements carefully so that they reflect the actual agreement of the parties and don't reflect sort of what the general agreement of the court tends to be. A good agreement is going to clearly define the action to be taken by both parties. So, for instance, if the tenant is agreeing to leave by a specific date, the landlord might agree to dismiss the case. If the tenant moves out, if the tenant agrees to pay, the landlord might agree to allow the tenant to stay. It's important that the agreement is specific about which party does what when and what the result of those actions will be. Settlement agreement has to be in writing and signed by both parties, and it should be provided to the court. It's a little bit different in county court where agreements can be read into the record. At justice court, they have to be in writing and they need to be filed with the court. An informal unwritten agreement at that level is not enforceable. Keep in mind, a settlement agreement may involve parties giving up rights, and they may impose penalties if a party fails to comply with the agreement. So, for instance, if you're a tenant and you're agreeing to move out by a particular date, the landlord may require as part of that if you don't move out, then they get judgment. And they may require that you waive your right to a hearing on any defenses you have. So settlements can be good if they meet your needs, but just keep in mind there are trade-offs here. And if the settlements don't meet your needs, there may be a problem. Make sure that you're not agreeing to do anything you can't do. The last thing we want to see is somebody enter into a settlement agreement, fail to basically meet the terms of that agreement, find themselves getting evicted, only to find out later they had real defenses they could have raised. So if you go to JP Court and you lose, there is an appeals process. Within 5 days, the court, within 5 days when the court issues the judgment, you can appeal by filing something called a statement of inability to afford court costs or paying an appeal bond. The court normally sets the appeal bond at 2 months of rent. So most people will do this via the statement of inability to afford court costs, simply because if you're behind on rent, you generally don't have 2 months of rent to pay to the court. The statement of inability to afford court costs fee, that can be obtained from the clerk's office. Make sure that you fill it out completely. You're going to be signing under oath and you return to the clerk. That needs to all to be done within 5 days of the court date. If you fail to appeal and you don't file within those 5 days, then the court judgment becomes final and the writ of possession can be issued at the request of the landlord. If you're appealing a non-payment of rent case, within 5 days of filing the statement of inability form, or we call it an IFP form, you have to make 1 month of rent payment to the court registry. That's required in order for you to retain possession of the property. If you fail to make that payment, you can still appeal, but at that point, the landlord can get a writ of possession. So just to sort of circle back, make sure the timeline is clear. There's a judgment against you on a Monday. You have 5 days to file your appeal. Technically, that puts you on Saturday, so that date rolls over to next Monday. You file the appeal timely. 5 days after you file the appeal date. So for instance, if you appeal the following Monday from the judgment, you have 5 days from that date to pay the 1 month of rent. And so then that rolls over to next Monday. If you don't make that payment, at that point, they can go get a writ of possession. Now, once the appeal itself is filed, the case is transferred to the county court at law. It's assigned to a court. You're going to receive some paperwork in the mail, so make sure you're checking that regularly. Normally, an answer is required in these cases. Basically, an answer is a document where you say that you disagree with the plaintiff's case. If you don't file that, in most cases, the landlord can move for default judgment. However, if you filed for an appeal using the statement of inability form, the failure to find an answer does not entitle them to a default judgment. Once the case is transferred to the county court law, after that first payment is made to the court registry, you then need to make payments of rent to the court registry in full and on time as they come due. So if you were evicted in September and you appealed, and the case landed in county court on October 1st, then it's important that you make another payment for 1 month of rent to the court registry for October, and then do the same thing again in November if your court day is at the end of that month. Failure to make those payments also entitles your landlord to a writ of possession. So it's important that those payments are made. Keep in mind that the statement of ineligibility can be challenged in some cases. We don't see this often, but it does happen. If the statement is challenged, it's important that you reach out to an attorney for assistance. It's important that, because the thing is that the court is going to have a hearing and they're going to be asking questions about basically whether or not you're eligible to appeal via statement of inability to afford court costs. So make sure that you have documentation about your income, any benefits you receive. And again, it's just easier to sort of navigate that process if you're being advised by an attorney. So just something to be aware of. So when in county court, all eviction cases in county court are heard, we call them appeals de novo. De novo means from the beginning. So basically, it's a brand new trial. It's, they're going to present their evidence, they have to prove it up, and you have an opportunity to respond. County courts use formal procedures and rules of evidence. So it's not like the justice court where it's a bit more easy to navigate. The courts do generally follow these procedures, and so they're a lot more alike. This is an area where if you really do need the assistance, we recommend hiring an attorney to navigate this. Justice peace courts, those are not courts of record. So what happened in JP court does not matter. So does not need to tell the judge what happened last time. That goes for both the defendant, but also the plaintiff. It's important to keep in mind that the plaintiff landlord has to prove up their case all over again from the beginning. And they also have to prove up their case with both testimony and evidence. And so sometimes what we see in justice court is that you'll have a property manager who doesn't know the facts of the case, who just sort of comes in and presents. County court is a bit more stringent in terms of what they'll accept. So, there are rules against hearsay. There are rules about what sort of documents can be admitted. So again, it's a totally different ballgame. It's something you need to be aware of. If you're unsuccessful in county court, the court does have a procedure that allows you to either get a de novo hearing in front of a presiding judge if you're in front of the alternate judge. Those motions have to be filed after 7 days. I need to update this PowerPoint to explain that. If you're in front of the presiding judge, or if you want to appeal to the Court of Appeals itself, there's 10 days to pay the appeal bond, which is normally set at about 10 months rent. Writ of possession can be issued in 5 days, however. And keep in mind that an appeal to the Court of Appeals is very different from an appeal to the county court. Like I said, the county court is a de novo hearing. The Court of Appeals is going to specifically be looking at the court record and be looking for errors. So just keep that in mind. Almost no cases are going to be eligible for an appeal to the Court of Appeals. And if you think that you have a case that might be eligible, it's vital you speak to an attorney before filing anything. As far as dealing with the judges, keep in mind that the judges have to balance accommodating pro se litigants and following procedural and evidentiary rules. It's very different from what you see in JP court. And so we recommend that if you need assistance, that you contact us or a different attorney for help. Now, some special cases that we see, public and subsidized housing has, in a lot of cases, different rules from what you see in normal private tenancies. Those can be additional termination requirements. So for instance, if you have a Section 8 housing choice voucher and your landlord files for eviction, before they do that, they have to give you a notice to vacate, but they also have to contact the housing authority that provided the voucher and provide them a copy of the termination notice. All of these special requirements, they're spelled out in either the HAP contract if you're on Section 8 or in federal regulations if you're talking about a different program. Keep in mind that public housing evictions involves not only termination of the lease agreement between landlord and tenant, but also can potentially imperil the housing benefits for the tenant because of the way those contracts are written. Public housing beneficiaries are going to be covered by CARES Act, so that's something to keep in mind. Keep in mind too, if you're in one of these situations where you're in public housing and you're being evicted and you need to appeal, the law requires that you are only responsible for paying your portion of the rent into the court registry. So if you remember when I said you have to put initial deposit of 1 month of rent down and you have to pay rent in full and on time as it comes due, if you're on public housing, you're only responsible for the portion that you would be responsible for under the HAP contract. If the court makes a mistake, you can file something called a rent contest. That is something where you basically ask the court to reconsider the amount to be paid into the registry. You need to file that contest within 5 days of the judgment being handed down. So it's very important that you're quick to file that. If you need assistance, it's another area where we highly recommend you talk to an attorney. These rules can be complicated, and we've seen even plaintiff lawyers who do this for a living make mistakes on this. So we recommend speaking to an attorney if you're on public housing and facing one of these evictions. So some other things that we see happen when the lease is breached, and we're talking about we call self-help, where the landlord, rather than going through a legal process, decides to try and solve it on their own. In most of these cases, these are unlawful. So the first thing you might see is a lockout. This is where a landlord simply changes the locks on your apartment. The second type thing we see is a utility shutoff. That's where the landlord either cuts off the electricity or water to the unit. For a lockout, it's important to note your landlord cannot exclude you from your unit unless it's done so for bona fide repairs, unless it's required in order to remove contents from a unit that's been abandoned by a tenant. In certain cases, a lockout is authorized under the property code if proper notice has been issued. It's important to note if you're talking about that sort of lockout, that is very different from an eviction. That is basically, if they're going to exercise rights under that part of the property code, they have to give you advance notice and they have to make a key available for pickup. So basically, it's not permanently excluding you from the unit. It's sort of a method in which some landlords try to get you to talk to them. We don't see it very much simply because it's hard to get right and because most landlords under those circumstances have already filed an eviction. So those are sorts of lockouts are very rare. And if you see one of those, again, talk to an attorney. Landlord can exclude you from your home and unit if judicial process is allowed. That's going to be an eviction. That's not going to be a normal self-help situation. Similar things are true for utility shutoff. Landlord can't interrupt your utilities unless it's for repair, construction, or emergency, or unless there are very, very special allowances made under the property code and in the lease. And again, it's very rare to see those, and it's even rarer to see those done properly. So even if you're behind on rent payments and you either have a utility shutoff or a lockout, you still have rights to sue your landlord over these. These cases start with ex parte lawsuits. So those are basically lawsuits that you file, without going through sort of normal service processes. If it's a lockout, we call that a writ of reentry. If utilities shut off, we call that writ of restoration. If you're facing one of those, as if you have been locked out or have had utility shut off and you're seeking to file one of these, you file a lawsuit in the precinct where you live. There are filing costs, but if you're unable to pay the costs, you file your petition with a statement of inability. That's the same form that we use to appeal the eviction suit. But basically, instead of asking them to waive an appeal bond, you're asking the court to waive filing fees. Make sure that while you're doing this, you're also documenting any damages you have in the event that you're locked out or you have a loss of utilities. This can be if you have to get a hotel room, if you have to basically buy bottled water, there are transportation costs, anything like that. You want to be documenting, what you're spending. You do not want to plead in these lawsuits that you've incurred damages. You want to wait, and you can file a separate lawsuit after the ex parte writs have been issued in order to basically claim damages. Specific to lockouts, if there is a lockout under 92.0081, if it's authorized by the lease, the landlord has to advance notice. So that's going to be in writing. It's going to be posted to the door. It has to include language that allows you to get a new key within 2 hours of making a request for the new key, regardless of the time of day. And they can't demand payment in exchange for the key. If they fail to let you in, a writ of restoration lawsuit is available, even if they've tried to do it under 92.081 and they failed. Once the case has been set for the ex parte hearing, you're going to see the judge. You don't need to serve the landlord, although we'd recommend giving basically a courtesy copy, advance notice to them that there's going to be a hearing. At those hearings, the judge is just going to want to know what's going on. It basically say, there's a lockout. I've lived here, I was locked out. I didn't get any notice, or I got notice this way, or they're refusing to give me the keys. You're basically telling the judge your story. The judge agrees you were locked out. They can order the writ of reentry to be issued. That is served on the landlord via constable, and it requires the landlord basically to let you back in the property. The landlord can ask for a hearing subsequent to the reentry. And again, basically, you're telling your side of the story, and they either have to prove that they gave you the advance notice or that there wasn't a lockout in order to basically win on that. Like we said, damages. Once you go through the writ of that should say writ of reentry. Once you go through the writ of reentry, if you win and you have damages that you'd like to collect, you can obtain those by filing a second lawsuit. In addition to your actual damages, which is basically all of the costs that you incurred, you can also get specific civil penalties under the property code. That includes 1 month of rent, $1,000 actual damages, expenses, court costs, and attorney's fees, less any delinquent rent. There's also an option to terminate the lease with the second lawsuit. So just be aware that, if this is something that's happened to you, you do have recourse, and you should talk to an attorney, if you need assistance in filing one of these. Utilities are very similar. You file the writ of restoration lawsuit in the lawsuit where the house is. You state your facts under oath. Again, you have an ex parte hearing. You do not need to serve your landlord prior to the hearing, although we generally recommend you put them on notice, either a courtesy copy of the petition or information about when the hearing is going to be held. If the judge agrees that the utilities were disconnected legally, again, you'll receive a writ of restoration, much like the writ of reentry. Again, the landlord has a right to ask for a subsequent hearing, but again, they would have to prove either that they followed procedure correctly or that there wasn't a shut off in order to succeed. And like the writ of reentry, if you have damages incurred because of the shut off, statute allows you to recover actual damages plus statutory damages, which I believe are similar to what you'd get under a writ of reentry. Finally, we're often asked about security deposits. A security deposit is a separate issue from the eviction itself. Your landlord is allowed to keep and deduct from the security deposit any amounts for damages and charges for which the tenant's legally liable under the lease. So, for instance, if you have a security deposit and you're evicted for non-payment of rent, and you go to court and you lose, or you settle and you leave, the landlord is in most cases still allowed to take the security deposit and use that to cover the back rent. If there's anything remaining left over, the landlord has an obligation to refund the security deposit on or before the 30th day after you surrender the unit. The landlord can deduct for damages to the property, back rent. They cannot retain any portion to recover we call normal wear and tear. Because, if you're living someplace, things wear out over time. They're not allowed to use your security deposit to cover those expenses. If the landlord keeps any or all of a security deposit and you want to get it back, they have to send a written description. I'm sorry, let me rephrase that. If your landlord intends to keep any or all of your deposit, they have to send you a written list with descriptions of the deductions, unless the tenant owns rent and there's no controversy concerning the amount of rent owed. So basically, if you're leaving and they're claiming that there's damages to the unit and they're going to be retaining security deposit, they have to basically give you an itemized list saying what the damages were and what they deduct in order to cover those damages. Some things to note. If you're moving out, schedule a walkthrough with your landlord, document the results. That way the landlord can't come back and claim that there are all these damages that weren't there when you moved out. Or if they try that, then you have, basically evidence that they're wrong. The timelines on this are largely triggered by providing the landlord a forwarding address. So make sure that you do that and make sure that's in writing. If the landlord wrongfully withheld the security deposit, you do have the right to sue them over that amount. If they haven't given an itemized list of deductions, there's a presumption that the security deposit was wrongfully withheld. If they do provide a list of deductions and you disagree, then it's really just a fact question about whether or not amounts were wrongfully withheld. So keep that in mind. Just to wrap up some additional tips. In our experience, if you're talking to us at the end of the process, we're very late in terms of resolving the issue. It's always better to get ahead of the problem and talk to the landlord as soon as the issue arises. For non-payment issues, there are still some rental assistance programs available. There are some private groups that provide those, but also there's apparently some money still available through 211. So if you're possibly behind on rent, we recommend, attempting to get rental assistance before giving up. And finally, if you're having issues with condition of the unit, make sure you pay your rent and then contact someone for help. Don't withhold rent. It's a good way to get evicted. Okay, and that sort of concludes it. Just to reiterate, we're at Lone Star Legal Aid a resource for tenants. And, it's what they pay us to do, is to try and help out in these cases. If you have questions or you're in doubt, ask for help. If you don't come to us, make sure that you go into credible groups, such as Houston Volunteer Lawyers or one of the housing clinics at the law schools. If you do need to apply, our information is here. You can apply at lonestarlegal.org, or you can call us at 713-652-0077. And with that, I am open for questions.
I don't see any that are in the chat, and I'm looking at my email now. So I want to make sure I get everybody else's questions addressed, because I had a couple of
Yeah.
my own as you were going down.
Yeah, and I know that's a lot of information, and sometimes it's hard to organize that, hitting all the topics. So, if there's anything unclear or anything that you'd want me to go over again, just speak up.
Okay, I would like to know if once a lease is signed, can it be revoked before the start of the lease effective date once it has been accepted and approved?
Um, that could be a fact-specific question. Generally speaking, once a lease has been signed, that becomes a binding agreement. I don't think it's hard to imagine instances, though, in which there could be there could be an issue that would allow one party or another to basically revoke acceptance of the lease. So if you're having one of those problems, I'd say go to an attorney, because again, that could be incredibly fact specific. But generally, once a lease is signed, it's a contract, and it binds parties to certain obligations.
So I've seen it before. I've heard people go through the scenarios where it's like um they were shown one particular unit when they get ready to move in, and then when they get there to upon moving in, it's like, oh yeah, well that one's not available anymore. No, you can't have that one. Then they move them to another unit.
Yeah, I mean, generally speaking, when you see a lease agreement, it's going to contain information about what the premise actually is. So the standard TA lease is going to say, this address at this unit,
Hmm.
and if they switch them to a different unit, potentially that would be a new lease agreement. Or if the unit number is different from the one that was shown, that could be a consumer rights issue. It's possible that that would be a DTPA claim or a breach of contract or some form of civil fraud. That would be something to bring up with an attorney if they have issues and they want to see if they have any rights to either get out of the lease, or if they feel like they're being held to an agreement that they didn't actually agree to.
Okay. Um, I'd like to hear how VAWA leases terminations are handled.
So you're talking about like your right under VAWA
Yeah,
for termination.
yeah.
There are sort of, I think, two grounds for that. The first is
Oh,
established
first, for folks that don't know what VAWA is, can you explain what that means?
yeah. So
Okay.
Violence Against Women Act is basically a federal law that provides certain rights to people who are victims of, either sexual assault or domestic violence. There are some properties, if they're receiving federal benefits, that may be required to follow federal guidelines. We've also discussed that there are state protections as well as far as terminating your lease. Um, I believe for VAWA, um, the important thing to note is that you should receive, well, if your unit is covered by VAWA, you should receive some form of notice that explains what those rights are, as well as basically a certification form. It's important that you follow those steps. If your unit is non-VAWA, you may still have rights under the property code. I'm actually going to go back and tell you which one that is. Yeah, so for family violence under 92.016, or for certain sex offenses or stalking under 92.0161, those sections are going to provide information about how to basically exercise your rights. I'd say I don't know those off the top of my head. I'd say it's probably fair to say that there's going to be some form of notice requirement. And so I would recommend, like, if this is an issue that you're dealing with, I'd recommend either contacting my firm, or there are other firms that specialize in serving victims, such as AVDA. So that's Advocates for Victims of Domestic Assault. They may be able to provide you more information and representation. If not, then I would refer to those parts of the code.
Okay. As the
And if it,
follow-up, oh,
sorry, and
go
if
ahead.
it is VAWA, if you do have that certification, that should provide you instructions on how to exercise your rights. I believe you need to certify, and then you need to provide notice. But there may be some additional requirements. I don't know off the top of my head.
Okay. Here's the follow-up to this one, and then I'll get back to the other ones that just came into the chat. If a domestic violence agency is a third party in a lease, and the lease is suddenly after the notice that there would be a year of rental assistance being dissolved due to the lack in available grant funding, is it lawful for the landlord to change the lease agreement and or terms because the agency is removing themselves from the lease?
I think that gets a little bit too fact specific for me to be comfortable answering that fully. What I will say is that as a general principle, if there's a lease agreement that sets out whether or not you have a third party paying the rent, and then you're paying a portion, the courts may treat that like a public housing case where you're only required to cover your portion. But again, there are going to be the lease is going to control in those cases, and I don't want to get into it too far simply because it would involve me actually looking at the terms, and I don't want to, I can't answer that question without getting into advice territory. So I guess that's an instance in which you really do want to either reach out to us or after one of the other legal aid organizations for assistance.
Okay. And then they have I'll be providing you all with the list of the resources and the links for each of the legal service organizations. But if you're just specifically trying to get questions for the person to answer that question, Houston Bar Association or a division of the Houston Law Referral Service has legal lines, and I'll include that phone number for you guys that you can just call, and it's like a over the phone kind of a consultation that they give you. I think it's like 30 minutes that they give you for like 20, 25 bucks or something like that. But I'll put their phone number in the chat as well as send you that link for legal lines if it's just general questions about your particular thing that you want to have answered to. Let's see. In a public housing unit or complex, is a landlord obligated to renew a lease for a Section 8 tenant, i.e., at the end of the lease, can the lease be non-renewed?
That's not a case I don't know off the top of my head. I think that you're allowed to basically end a lease at some point under Section 8, but I don't know what's specifically involved in that. There are other programs. So for instance, if it's low-income housing tax credit, there does need to be good cause to terminate certain tenants. I mean, even non-renewal at that point. Section 8 is a little bit different because they are private landlords and they're not receiving the tax credit under low-income housing tax credit. So that's another instance in which I think the answer may be yes, but there are going to be some nuances depending on who actually is accepting the Section 8 housing voucher.
How would
But
a,
again,
oh, go
sorry,
ahead.
again, I don't like a lot of that is going to be established under the HAP contract. And I don't know that section of the HAP contract well enough. You may review that. If it says that, they're required to renew you, then that may be binding. So just be aware the HAP contract, I believe, would control in that case. That should be your takeaway.
Okay. How would a non-lease renewal need to be communicated, and how far in advance would the landlord need to provide that information?
That is going to be established in the lease. If it's not established in the lease, it's going to be 30 days. Well, actually, let me rephrase that. In order to terminate under just a statute, you're required to give a 30-day notice. If they're non-renewing and they give you less than 30-day notice, it could convert to a month to month, or it could be that they'd have to follow up with a new termination notice at the end of the lease term.
So,
Um,
so if this is October 15th, they can't just now send you notice like, hey, beginning of November, we're not renewing your lease.
well, they can send you a notice saying they intend not to renew your lease, but if they don't give the 30-day notice, they're going to have trouble bringing an eviction suit for a holdover
Okay.
unless the lease says something else. And that's the thing, is that that's a timeline that can be altered by the lease, so you're going to want to review that.
Okay. I heard, and I'm going to get to my questions now. There are no other questions here in the chat. I just want to make sure that I don't have anything else. There was this thing that's been all over social media. And I like to ask the attorneys of this in this kind of a setting, because I know everybody goes to the street committee. Everybody likes to listen to everything on social media about, what they think the law is and how it applies to Texas and so on and so forth. There was some, and it's been a lot of controversy and talk and discussion about someone that had passed away that had an apartment or had a lease or something to that effect, that
Mhm.
the apartment complex tried to sue the family or the estate for the remaining balance that was left on the lease when the tenant passed away. So when a tenant passes, is the estate still obligated for the remaining balance of the lease, or does it end with a person passing?
Um, the lease can be obligated for back rent. So while the person was still alive and still accruing rent, they can basically ask for that. If they're given a notice under 92.0162 that this person is passing or terminating the lease, that allows them to avoid future liabilities. So, if the guy is, you know, buried and they're asking for rent, after, you know, the decedent was passed and after they were informed, that's a problem. If you're asking for back rent and back rent was owed, then yeah, they could ask, they could be a creditor to the estate.
So at what point or how much time is allowed then, once a person has passed, notice has been given that they have to remove the property from the unit? Because at that point, if all of their possessions are still occupying the space, what happens then?
So I don't know 92.0162 off the top of my head. It's not a fact pattern I've dealt with recently. Um, I the statute probably provides some timelines there, and if not, I would actually be pretty surprised they didn't provide some timelines. One thing we do see is if there is a situation where someone has passed and the unit has not been surrendered to the landlord, I have seen basically deceased persons being evicted, where the landlord comes and basically asks the court to authorize the apartment complex to go in and remove the items. So that is something you do see, but again, I'd imagine the timeline would be set by the property code.
And without getting too far into like probate as it relates to evictions, is there something that someone would need to provide to the landlord that authorized them to remove somebody's possessions from the, so if, like, my grandmother passed
Mhm.
and her things are in this unit, we know that we need to clean out, move it, whatever, whatever. Am I required to provide something to the landlord to say, hey, this is my grandmother's unit, I need to remove her belongings from here, give me access to the unit?
Um, that's a very good question. Certainly the probate court could provide letters testamentary to whoever is administering the estate. Um, yeah, I don't know beyond that whether there's some form of temporary letter that you can obtain, basically just for the purpose of removing things from a unit. Frankly, I don't know that. I think the opposite problem would be an issue where basically someone talks to a landlord who maybe doesn't have the best interest of the estate in mind, and
Mhm.
landlord lets them in to remove things. So I don't know if there's anything specific, legally speaking, that someone can get to show the landlord that they're required to get access. I think in most cases, if the landlord has provided notice that the person has died and you're asking for access to remove the stuff, the landlord would, assuming that there's evidence the person died, allow them in. But again, it's not a fact pattern that I've ever seen play out. So I, at least in part, speculating.
I just thought about that. That's a question I'll ask at one
It's
of
a
our probate presentations. But
yeah,
I just thought about that.
it's a very good question, and I'm curious to know what the answer is.
Oh, well, if you're here for next month, if you're presenting next month, I'll make sure that I bring it up, because I'll definitely find out um about that. My other question is about what do you call it? The pets and the what's emotional support animals and things of that nature. How are is a landlord allowed to evict someone when an emotional support animal or a service animal comes in after they've signed a lease when they didn't have the animal from the what are the rights there as it relates to that protection, being charged rent, security deposits, and things like that for tenants?
So generally speaking, service animals are different from pets
Right.
and they're treated differently. And so if you're talking about someone has to get a security, I'm sorry, has to get a service animal after moving in. I mean, certainly you want to notify the landlord in those instances so they're not basically shocked about this.
Mhm.
But yeah, you have rights to have a service animal, and they can't evict you for, let's say, not paying a pet deposit when you have a service animal. There are rights for emotional support animals, but because emotional support animals are, it's a little less strictly regulated. I think there are more open questions. If this is something that you are experiencing where a landlord is trying to evict you because of an emotional support animal, I'd recommend talking to an attorney. It's going to be fact specific. It's going to, again, another statute that I simply haven't memorized, or those revolving around emotional support animals. But service animals, no. A landlord cannot, basically attempt to evict you because you need to get a service animal and you got a certified service animal.
I was just curious about that because I've seen a lot of people now have emotional support animals, not necessarily service animals, but have emotional support animals, and they are animals of all sorts. So just was curious about that, and
Yeah.
especially on those properties where there's like a no pet or a restriction on a particular breed of a dog or something like that.
Yeah.
Uh, okay, let's see. Let's see. Are there special circumstances under which an eviction can be sealed?
Um, Unfortunately, not anymore. We used to have the emergency order from the Texas Supreme Court, which allowed courts to seal files when basically both parties were participating in rental assistance programs. They chose not to renew that order. I think we're coming up on 2 years now. And basically that took away the ability of the courts to seal files. So unfortunately, no, you know, they might bring it back in some form or fashion. I think that that was a program that was popular with some of the judges, but it's something that right now is not available to anyone.
And from my understanding also, for evictions, evictions are only shown as collections on credit reports now that get reported to the bureaus, not necessarily the actual eviction itself.
It's complicated. The way I kind of break it down for people is there are two types of reports, and there are three ways in which it might show up. So in terms of credit reporting, where it's basically, do you owe do you owe something to somebody? It's going to show up like other debts. I owe, John landlord X amount of money for, something. The one that's I think more relevant to tenants are what we call tenant screening reports. Those are reports that landlords basically order and generate in order to see whether or not they want to rent to somebody.
Mhm.
And they're not as strictly regulated as credit reporting, and they contain a broader amount of information. And an eviction can show up one of two ways. The eviction judgment, if basically the final judgment against you is not appealed, that can show up as a judgment, and that's very negative. And there are a lot of landlords who will deny people basically a lease because there's been a past eviction. So that's one way it can show up. The second way it can show up is if there's an eviction, but it's been dismissed or you won, the filing is still reported. And so even if you win an eviction suit, there may still be a way in which your landlord knows that you have basically been sued for an eviction. And at that point, it's an open question about what the landlord wants to do with that information.
Hmm.
And I don't think there's an industry standard about that. Some landlords are going to look at that and say, well, yeah, there's an eviction filed against you, but it doesn't look like there's a judgment, so we're good. Some are going to say, well, there's an eviction filed against you. I don't want to do business with you. Some might say, well, this is a higher risk tenant, so I'm going to want more of a security deposit. A lot of different, possibilities there.
When you've got a scenario where you've got property management or property managers kind of change management of different properties, all the time, basically depending on the change of ownership and so on and so forth. So if you've got a property management company that is new to a particular property and they have their own regulations and rules or whatever that were not in a previous um, lease or not in the previous guidelines, regulations, property management rules, are you to now adhere to what's new or versus what was originally signed in your lease, especially if your lease is not up?
This is an instance in which, I mean, it's a complicated question. This is an instance in which if there's a question, you may want to talk to the property management to find out, what the needs are. In most cases, the main changes may be if they're adopting a new system, like a new payment portal, or if they are changing community rules. The community rules is easy to follow because they should be providing everyone a written copy of those. And those are going to act like addendums. You just follow those. Um, they can possibly alter the way in which they ask you to pay the rent. So for instance, changing the address of where you're paying, they're not allowed to change the amount that you're paying as in terms of rent. That's established by the lease. Um, I mean, it's something if there's questions about, what are the policies, I'd ask the management company, but just keep in mind there are certain things they can change, such as where something's paid, and there's certain things they can't, how much is paid. And so it's just sort of, figuring out what the rules are supposed to be and then making sure you're following them.
Now, I've seen plenty of times as it relates to the payment methods and things of that nature that some property management companies they switch to like an online system where you have to pay through a portal and they charge you a fee to pay like with a card or through the check, or they charge you a fee basically.
Mhm.
So if I'm paying my rent is my rent, and now I have to use your portal in order to make my payment, but you're now charging me a fee for it. Are they required to give you some other alternative, or can they make you pay through that portal?
That's a good question. If that's something that you've seen, that's something to talk to an attorney about, because there may be some consumer rights issues involved there. Excuse me. I'm going to have to get back to that. There may be some. Yeah, can I stop sharing for a second?
Sure.
Sorry, that was a paralegal. I wonder if they had an answer to a question that we've gotten. I just want to see.
Well, while you're doing that, I'll just
Yeah,
kind of keep rambling a little bit. But I've seen that even when I lived in my old apartment and they switched to that portal, I was highly upset that they tried to make me pay through
yeah.
this portal. I'm like, my rent is my rent. Now, why will I all of a sudden have to pay you a fee to pay you?
There may be some
That
consumer
makes no
rights.
sense.
There may be some consumer rights issues there because, potentially if that is a fee that is not authorized in the lease itself, then it might be something that they're not allowed to collect. My recommendation, if you're facing that, in addition to talking to an attorney, is at least initially to pay it so that you're current on rent. And if there's a real issue there, obviously you can talk to the management and see if they're willing to accept things through money orders or through things like that. But the concern is if you don't make that to pay that fee, and then you're not paying rent or they're refusing rent because it's not tendered the way that they've asked it to be tendered, then potentially you're talking about an eviction issue. And evictions don't have counterclaims. You can't say, well, I want to pay it this way, but they're defrauding me because they're charging me this convenience fee.
Hmm.
Or at least And so it's better to avoid the eviction and then potentially talk about either a small claims case or something like that, or maybe filing a demand letter, than it is to try and litigate this once they're claiming that you're in breach of the lease.
Gotcha.
But yeah, that is something that I would recommend speaking to an attorney about, because I do think that they're potentially consumer. I'm not saying there's a case, I'm not saying there's not a case, but it's something to look into if you have that issue.
Okay. Was just curious about that. All right. I believe those were all of the questions that I had. And I don't see anything else on social media. And that was all I had that was emailed as well. So if there's no other questions, well, thank you very much, Ms. Denise, for your questions and for your input, and for all of the other participants that are joining us today. We thank you very much. Mr. Daly, thank you for taking the time out also representing Lone Star Legal Aid to provide this information. We do hope that you all found the information to be beneficial. We do ask, along with all of our other presentations, that you do pay it forward and share the information that was provided here today for someone that you know of that may or may not be, facing eviction. And unfortunately, a lot of people's pride get in the way and they don't, think about it or talk about it or want to ask anybody about any kind of assistance or anything. But even if you just kind of talk about it in passing to let folks know, hey, options are out there, is available. Don't wait until the day before you're supposed to show up for eviction court and then try contacting an attorney. Please make sure that you communicate with your landlords and reach out to whatever services that are available to you to keep you from being evicted. So with that being said, thank you all very much once again. You all have a wonderful remainder of your day. Tomorrow, what we've got, maintaining and adding value to your home. We also have our first time homebuyer education class that's scheduled in person this Saturday on the 19th at 9 a.m. That information is posted on the website. Next Tuesday, we have the Coffee and Conversation Resource Fair, as well as our property tax workshop and foreclosure prevention next week as well. So with that being said, thank y'all very much. Nope, one more thing. We do have our senior security as part of the Neighborhood Recovery Senior Security Series, retirement planning and Social Security and what it is that you need to know about how the two work together. And there's a lot of stuff in retirement planning that I didn't know about until recently. So definitely want to look into that. Did you put the information in the chat for contact the attorneys? I did not. Let me put legal lines information in there right now for you. Because I know I have it like really handy. Legal lines, legal
Yeah.
lines, legal lines. Houston Bar Association legal lines is 713-759-1133. I wanted to say that aloud for the folks that do not have access to the chat. Legal lines is 713 13, if I could type correctly, 759-1133. And it is there in the chat. You can reach out to Legal Lines. But again, I'll make sure that it is included along with the link for Lone Star Legal Aid if you wanted to reach out for them for additional information as well. So you all have a wonderful remainder of your day. You take care of yourselves, stay safe, and we hope to see you all again next time. Thank you for joining.
Thank
Bye-bye.
you.